crypto, the notion that SEC Chairman Gary Gensler is quitting has swept Twitter. John Deaton, an attorney who is in favor of XRP, has responded on the speculations suggesting that a resignation from Gensler is probable. John Deaton, an outspoken advocate for Ripple, has predicted that in her future summary ruling, Judge Torres would provide a detailed answer to the topic of whether XRP is a security. XRP was once sold as an investment contract, SEC shavers, but that particular sale didn't transform BTC into anything other than what it is, a digital commodity, he said. Deaton further said that Judge Torres will address the problem of secondary sales using XRP, which is something many seasoned attorneys would rather avoid. The underlying asset and secondary market transactions are issues that I think Judge Torres has to consider. Was she able to rule without becoming bogged down in the details? She could, of course. However, not addressing these issues would be an even greater act of judicial activism than considering the sexist theory, he said. Deaton used a case concerning the Telegram messaging service from the year 2020 that was heard by Judge Castile to buttress his claim. The SEC's decision to intervene and prevent Telegram's planned distribution of Gram tokens marked the beginning of this legal conflict. After a failed issue ICO for the Telegram Open Network, Judge Castile sided with the cease and ordered Telegram to pay back investors $1.02 billion. Remember that the SEC's position was that Ripple's behavior resembled that of an iShow on an ongoing basis, with each sale of XRP being seen as part of a larger scheme involving securities. Deaton, meanwhile, made it clear that the XRP issue was different from the Telegram case since the latter comprised an initial coin offering, IQ, with written contracts. Deaton said that the XRP ledger, XRP, technology, which underpins XRP, has been in use and freely traded for over 7 years. Unlike the Gram coin, which was restricted to anyone outside of the SEC, XRP was allowed to be owned by anybody until 2019. The dispute between the SEC and Ripple centers on the question of how XRP may be traded on the secondary market. The SEC charged Ripple with providing an unregistered securities, but it did not differentiate between Ripple's direct sales and the secondary market trading of XRP, which led to some misunderstanding. Deaton has speculated that Judge Torres may explore this issue because of an earlier examination in the SEC El-Bri action. Judge Torres' summary judgment ruling might provide clarity on XRP security classification, which could have far-reaching implications for the cryptocurrency sector. Judge Phyllis J. Hamilton of the U.S. District Court for the Northern District of California has ruled in favor of a class of investors in the class action lawsuit Zakhanov. Lawsuit Zakhanov E's, Ripple Labs and C, marking a significant moment for SERP investors. The main claim is that Ripple is breaking the law by not registering XRP as a securities under federal and state regulations. A huge number of XRP buyers can now pursue securities lawsuits against Ripple, XRPU, and CEO Bradley Garlinghouse, according to this verdict. 2 months have passed since the last court date in the XRP investor class action lawsuit against Ripple. Bradley Sostek, the main plaintiff, filed a request to certify a class of all XRP holders worldwide who purchased, still hold, or sold XRP at a loss. Although defense counsel successfully argued for the action to be limited to us investors, despite Ripple's global presence, this order affirms the right of us investors to seek legal recourse. Judge Hamilton acknowledged the dynamic nature of the law as it relates to cryptocurrency. This ruling marks a significant step forward for the lead plaintiff and his legal team who allege a loss of $118,100 after selling XRP in 2018 due to Ripple's misleading claims regarding the token's security status, as she emphasized the need to allow individual jurisdictions to enforce their need to allow individual jurisdictions to enforce the cryptocurrency regulations. This paves the way for additional XRP investors to join the class action in an effort to recover their purported losses. Defense attorneys for Ripple and Garlinghouse contended that class members' divergent opinions on whether or not XRP is a security would cause friction within the class. This argument was shot down by Judge Hamilton, who said that any issues could be settled using the usual opt-out method. Nick Spear of Sussman Godfrey was pleased with the court's judgment and excited about the next steps in the lawsuit. A representative for Ripple emphasized the significance of letting other nations regulate cryptocurrencies independently, citing the court's rejection of a worldwide class. As an example, the representative also confirmed that the court is prepared to wait for the conclusion of the XRP Ripple case before moving forward, while the industry waits for the result in the XRPs. Ripple Labs' legal dispute, a lawyer has speculated on when the verdict would be released based on the summary judgment ruling history of Judge Annalisa Torres. Attorney Fred Rispoli, who is on Ripple Labs' side in the continuing legal struggle with the U.S. Securities and Exchange Commission, has speculated that the court's verdict might be released in August. The attorney used data on the federal judge who is presiding over the case, Annalisa Torres of the United States District Court for the Southern District of New York, to emphasize that 60 of the judge's rulings came between 146 and 330 days, with the judgment announced in an average of 240 days. From these numbers, we may infer that the verdict was due on September 17, 2022, or 249 days after the original move for summary judgment was filed, which would be May 21 this year. Since that month has passed without any word from court, that argument is no longer valid. Rispoli also considered using the 330-day criterion to the XRPs. Ripple Labs' case, which would likely result in a judgment by the court on August 10 of this year. Between 146 and 330 days, 60 of decisions are made. That's a total of 330 days or till August 10, 2023, or 249 days from September 17, 2022, which is May 2022, which is May 2023. The attorney added after receiving what might be the finest or worst birthday present of his life. Which one of the two? John Deaton, another crypto law pioneer and pro-Ripple attorney, projected using data that Judge Torres' ruling may come out on September 6. Rispoli's prediction is somewhat earlier than Deaton's. Deaton based the September 6 deadline on the March 6 order by Judge Torres on the Daubert motion in the Ripple Labs complaint. In one case she issued a summary judgment ruling 6 months after ruling on Daubert. According to what Deaton mentioned during the broadcast, 6 months from her Daubert decision. If it were on March 6, it would be September 6. In May, Ripple Labs CEO Brad Garlinghouse said that the company believes the legal fight is coming to a close and that a ruling might be issued in weeks' time.